So with that, can we do a welcome to Will with the hand clapping? Okay.
Thank you.
Will, did you see that?
Yes, I did.
Great. Do you feel welcomed?
I feel warm and fuzzy and welcome. Thank you.
So, Will, I want to keep the intro really short. So if you can tell us briefly what you do and maybe just jump into maybe a 3 to 4 minute description of the privacy landscape as it is today.
Sure. So as was mentioned, I'm with UBM Law Group. Most of my practice, or a large part of my practice historically, is negotiating tech contracts, SaaS agreements, software licensing, that type of thing. And that's what pulled me into data protection and privacy. So I help companies, say a SaaS provider, develop a GDPR compliance program, that type of thing. And so, yeah, in terms of the privacy landscape, we have kind of things coming to a head on a couple fronts. We have Europe spending about 6 years negotiating an update to their 96 privacy law. That's called the GDPR. Most people have probably heard of it. It was passed a couple years ago and went into effect last year, just about 1 year ago. And then we have that was sort of a well thought out process, built on a whole history of data protection laws and conventions in Europe dating back to World War II. And then in California, you have a kind of a different approach. You had a ballot initiative that kind of gained unexpected traction last year. And the challenge with those is that when you pass a law by ballot, the legislature can't soften it or amend it particularly easily. And so when that sort of took on steam in the wake of Cambridge Analytica in particular, the legislature and the private industry got with the backers of that initiative and said, hey, if we pass a law by the deadline for you to pull this ballot initiative, will you pull it? And so they struck that deal over a course of a month. They drafted the law in about a week. So again, contrasting that with the GDPR where they spent 6 years. And boom, we have this California Consumer Privacy Act that was passed last year and goes into effect January 1, 2020. And it sort of can be thought of, we can get into what they say, but think of the GDPR as a very broad data protection regulation and the CCPA as a sort of a narrow subset.
How does the GDPR and the CCPA affect us as CTOs and how we manage data when our companies are based in all these different places around the globe?
Sure. So the GDPR, just quickly, why it kind of came onto the radar so much in the U.S. kind of relates to your question. When they created the GDPR, they expanded the territorial scope to say we're going to pull in companies wherever located that are offering goods and services to European residents or monitoring their behavior. So you could be literally anywhere in the globe, and if you're doing that, then you're ostensibly subject to the law. The other thing that kind of brought it on the radar was they dramatically increased the potential fines that can be levied up to 4% of global turnover, global revenue for the corporate group. So that obviously heightened the profile. So in an age where you have lots of multinational companies, or say you're a SaaS provider to a large multinational, it's very likely that they'll have a European footprint or exposure and want to flow down compliance obligations to you as a SaaS provider. Or you could actually have a presence in the EU that would pull you in, or if you're just actually offering goods and services or monitoring Europeans, you're pulled in and technically subject to the law.
If I have 10 customers, 10,000, 1 million, how is it all the same, or do I have to consider CCPA for any amount of people?
Well, CCPA is a little different. It does pertain to California consumers, which is really defined as a California resident. And you have to be pulled into that. Again, you could be located anywhere, not just in California. You have to be a for-profit business, doesn't cover nonprofits. doing business in California, which can be kind of loosely defined. And then you either have to have at least 25 million or more in revenue, or you have to be collecting the data of 50,000 or more people, households, or devices each year, or you have to be deriving more than 50% of your revenue from selling people's data. That second one, collecting 50,000 or more data points, that's the one that could pull in a small company, because that could be IP addresses hitting your website from California, that type of thing. So you could be a fairly small organization and get pulled in on that one.
Crazy. I guess it's time to block IPs from California.
137 if you divide the 50,000 up per day.
Got it. Got it.
It's just a simple math, but you know, pulling in concepts like household, it's not defined in the law. Nobody knows what that means. So what does it mean to collect the data of a household, maybe or perhaps an Alexa device, something like that. So how you monitor that, or how you look at a data stream and say, these are the California ones and these are the other ones, is kind of anybody's guess. So
what would, I guess for people like myself, I think of GDPR and CCPA as something way over there. Like, I'm building my company here, we're focused, we're running hard. I'm curious to know, what is an event that triggers some sort of audit or some sort of lawsuit? Is it consumer driven? Are there firms launching as we speak, focused on exploiting and these case studies?
So for the GDPR, if you're say a SaaS processor and you're subject to the law under the parameters I've described, you're technically subject to the authority, theoretically subject to the authority of the data protection authorities in Europe. But practically speaking, if you're a small organization, are they going to prioritize you in their enforcement efforts? Probably not. So you could be sitting here and be theoretically subject to the law, not complying with it, and the chances of them just jumping over and sort of doing something to you is probably low. And that assumes you don't have any presence or assets in the EU. That assumes that's disregarding reputational risks of an enforcement agency coming after you from Europe and saying, hey, we think you violated this and that, and suffering the reputational harm. So there are a couple things that can actually make the enforcement risk jump up to that company that I described. One is that you decide that you want to become Privacy Shield certified. And so probably many people have heard of Privacy Shield. It's an agreement between the US and the EU that blesses transfers of data out of the EU, personal data out of the EU to the US. So that's one of the concerns of the EU is, hey, we've got this protective bubble around personal data here, but if it goes off to what's called a country without adequate protections, like the US is deemed, then it's not subject to those protections. So what are the measures that will ensure that it continues to have that protection? Privacy Shield is one avenue for that. You pay $1,000, I think it is. You agree to abide by certain principles. You stick things in your privacy policy addressing Privacy Shield, and you agree to be subject to the enforcement actions of the FTC or the Department of Transportation. And that's where suddenly you've agreed to directly be under that jurisdiction, and they could come after you. So some people think, oh, well, I'll just become Privacy Shield certified. They confuse that with an overall compliance to the GDPR, which it's not. It's just addressing that international transfer. And then they've just created, they've just increased their risk profile for enforcement because they've agreed to be subject to US enforcement. The other way that you can be sort of practically exposed to enforcement risk is if your customer wants to be compliant with the GDPR or is subject to it, say they're a big multinational, and you're handling their data, you're a SaaS provider, for instance, they're going to contractually come at you with something called a data processing agreement, and that's required by Article 28 of the GDPR. It requires that they flow down all those obligations, and you're wearing what's called a processor hat. You're processing data for them at their direction. And so there's a contract that they are required to put in place that says you're going to meet the obligations of a processor. And if you don't do that, you might have uncapped liability under the contract. So if they get hammered by the enforcement authorities because of your failure, they can turn to you and say, hey, you agreed to indemnify us for this giant fine we got. So that's another practical way. If your company is receiving some customer or somebody is handing you a data processing agreement saying sign this, that's a signal that they're saying we think you're a processor for us under the GDPR.
So what are the benefits of Privacy Shield?
The benefits of Privacy Shield are there's only a few ways you can legally bless transfers out of personal data out of the EU to another country. For the US, one of those options is Privacy Shield. Another option is something called model clauses, which is a set of contractual clauses that have been blessed by the EU that say we're going to comply with European data protection law, etc. So if you have a business on the other side, you can enter into model clauses to bless the transfer. But if you're just a company directly grabbing consumers' data in the EU, you're a consumer-facing app, for example, and you're collecting their data, there's no model clause, there's no counterparty to enter into model clauses to handle it that way. So you really just have to be Privacy Shield certified. There's one other way that you can bless transfers called binding corporate rules, and this would be for bigger companies where they have an internal code of conduct among their various subsidiaries that allows for movement of data transborder within their group, and that's not really applicable to smaller organizations.
So I was just thinking about this in terms of financial services. So I've run into the Graham Leach, the sort of GLBA, which is about the sharing of data in the financial services, right? So banks are often sharing data for marketing purposes, but also and affiliates, but also for services like check production and that kind of stuff. So you can opt out of data sharing with your institution. So if you go to your bank's website, it will say because of this act, that will say what data they're sharing. But there are some instances where you can't opt out of it. And that exception is one of the things we've used in the past to kind of hide behind all the requirements as a kind of B2C fintech, which is we're providing a service under this exception. So we quite often would get customers saying, delete my data. But what was handy for us was we would just refer them back to their bank or their issuer to do that. And I'm wondering if those type of exceptions, you were just touching on some of it in terms of sharing between under that privacy stuff, but whether that, where it is impossible to perform a service function without that data sharing, whether there's those sort of exceptions that we should be thinking about when we're trying to conform to the standards or to the regulation.
Sure. I can speak to that in a general sense. Some of it gets into to the GLBA that I won't dive into, but
no, don't please.
Yeah, spare you. So the GDPR, interestingly, a couple things about it. One is it has this thing called sensitive categories of data, which you would think might be things like financial data, but is not. It's more about trade union membership, ethnicity, medical information, social, cultural, things like that, religion. Not that they don't think of a social security number or a bank account number as sensitive. They do recognize that some data is more sensitive than others, but they're not really there's obviously no speaking to GLBA. But what the GDPR does have is, unlike the CCPA, it's a broad, comprehensive data protection regulation, And so it's not just concerned with security and privacy and sharing, it's concerned with purposes. What is your purpose for processing data? And does it fall within a number of enumerated categories that are quote unquote legal bases for processing data? One of those legal bases is entry or performance into a contract. And so if you're I don't know if you're talking about this, but if you're saying, consumer is saying, hey, do this thing for me for a fee, and then you need to process their personal data to deliver on that, that would be a legal basis, as long as it's necessary to, it's not sort of, you're doing it for your own purposes, but you're actually doing it to fulfill on that contract or to negotiate that contract, then you're okay under the GDPR. That's a legal basis. Another legal basis is consent. So if you have explicit consent, then that's okay. The problem with consent, and this is sort of when you talk about misconceptions about the law or misunderstandings, people think that consent is required in all instances and the end all be all, and it's not necessarily the legal basis you want to choose if you can avoid it. We can talk about that a little bit later, but the problem is the GDPR heightens what constitutes valid consent, so it's harder to get, and then it must be able to be easily withdrawn. So if you're relying on it and you're motoring along and then somebody withdraws it, that can be a problem, and you're not allowed to say, oh, well, you've withdrawn consent, but I have this backup legal basis that I'm going to fall back on. You can't really do that. So entry into contract would address, I think, the kind of things you're talking about potentially, unless it's sort of, not required to fulfill on the contract. For CCPA, they expressly speak to the GLBA and HIPAA, and they say that data that is sort of within the rubric or governed by those laws, like PHI under HIPAA, for example, that is exempted from the CCPA. Meaning, if you have financial information that's being regulated by the GLBA, then it's subject to the GLBA, not the CCPA.
And the GLBA, just for us who don't know what that is?
Gramm-Leach-Bliley Act, it's an act that governs financial information, the security and protection of financial information. So in the US, historically, the landscape before all this was sort of like a sectoral approach. We identify a certain area of information that we feel needs protection, like fintech or financial information, and we pass the GLBA that requires certain protections around it. Or health information, we pass HIPAA. Or children's information, we pass COPA. And then we have 50 breach notification laws that simply say, hey, if you breach sort of sensitive, like social security plus name, you got to notify people within a certain amount of time. And that's it. Outside of that, it's sort of do whatever you want.
Okay, and Jeff, why don't you ask your question?
Yeah, I was wondering if the GLBA coverage would extend to all PCI covered data, or is it just a subset of the PCI covered data?
I don't know if I have a good answer for that. I think of PCI is a kind of a specialized area that I don't have to delve into. I think of them as different, PCI and GLBA, but I suppose they could overlap. Can you maybe rephrase the question?
I'm just wondering, because we do store a fair bit of information, all of which goes through PCI compliance certification.
Mm-hmm.
And I'm just trying to figure out how much of the CCPA we're going to have to worry about, whether we do or whether we can take the position that we're covered under GLBA. So
if you are processing credit cards through a third party, PCI compliant, but you're storing some sort of token in your database to kind of track the transaction or have a reference to the transaction or something like that, would the storing of those tokens against user IDs be some sort of violation or some subjected to these types of laws?
Well, I guess a way of answering that question is if you can construe the data as being subject within the scope of GLBA, then you're totally taken out of law as to that data. If it's outside the GLBA, then you're subject to the law, and it covers personal information broadly defined. So
Okay.
any data that could be reasonably associated, or actually not reasonably, any data that could be associated with a person. So if it's tokenized, but somebody, you could trace it to that person, then it's subject to the law.
Is there sort of a common misunderstanding when you do work with CTOs where we might think that it's this kind of data, but it's actually much broader than that?
Yeah, absolutely. I talk to CTOs and other tech people, and I try to explain the definition and breadth of personal data under the GDPR or personal information under the CCPA, and they have trouble wrapping their head around it because it's so broad. So typically historically they'll want to say, oh, it's name, it's email address, it's something that directly identifies a person, it's their bank account, it's their social security number, that type of thing. But it's much broader than that. So under the GDPR, it's information about an identified or identifiable person. So what that means is, for example, if I have a database of encrypted personal information that sort of says John Smith and then has his shoe size and a bunch of other information, text messages he sent, anything about him, and it's tokenized or it's encrypted, that's personal data under the GDPR, even if I don't have the key for the encryption. If that key exists somewhere else, I don't have access to it. The fact that I can't unlock that data and see it doesn't mean that it's suddenly not personal data and subject to the regulations under the GDPR, because they're concerned that that information could get out of your hands and somebody could marry it with this other data and suddenly unlock it and see it. So when you talk about anonymizing data, it sort of starts to get really difficult to do that, because stated another way, a personal data would include a guy of a certain age who lives in Carlsbad who runs an organization for CTOs. Now, that doesn't say a name, but if there's two people or one person in the world that would identify, then that's personal data. And you can see the challenges of having to be able to track that down, control it, delete it, segregate it when it doesn't directly identify that person. And then the CCPA is similar. It's anything that could sort of anything that could relate to a person, household, or device. And it may be that the amendments floating through the legislation will get rid of that tricky household concept. So hopefully that will happen, but it's sort of a broad, anything that could be associated.
Our SaaS product allows any organization to come to our site, add their employee information, and their employees actually do a personality assessment.
Mm-hmm.
So my question was, is the account owner considered a data processor, since they add these people, they could download them as a CSV, and they have access to everybody's personality report? So do they have to sign an agreement?
Sure. Under the GDPR, first of all, the GDPR has these two hats. One is called controller,
mm-hmm.
and one is called processor.
Mm-hmm.
Those people that you're talking about, those end users of your customer, would not be deemed processors.
Okay.
So controller is the person or the organization that decides to embark on the processing activity. So they're a company that says, hey, we'd like to do personality tests. We're deciding to initiate that collection and processing activity, and we're going to turn around to your company to make that happen. Mm-hmm. And so you contract with them to provide that service, and as long as you're only using the data to provide that service, you're deemed a processor to them. As soon as that user uploads the data, you're touching it, you're doing things with it, and you're sending it back to them, you're their processor. Now, if you chose to say, hey, I am going to monetize this data, and mm-hmm. I'm not saying you are, but if I'm deciding to do something else with that data, you will turn yourself into a controller, a separate controller. Yeah. And now you're subject to all the regulations applicable to a controller. And where it gets into a little bit of a gray area is that processors like SaaS companies are often using data to improve their service, kind of internally, and that's very common. So that kind of gets into a little bit of a gray area of sort of maybe looking like a controller.
Mm-hmm.
You got to be careful with that.
Okay.
When you're aggregating data,
Mm-hmm.
how does that apply to what you just said?
You're a data broker.
Yeah.
In a sense, you're aggregating data. So so under the GDPR, the challenges there are that I'm going out and I'm scraping publicly available data, which again, public information, people would think, oh, well, that's not personal data regulated because that's freely available publicly. Well, it is personal data, even though it's publicly available. So I'm a business. I go out and scrape the internet for public data. I aggregate it from multiple sources. Once I have that data under Article 11, I'm supposed to, if I don't collect it directly from the consumer, I'm supposed to circle back to the consumer and say, hey, we've collected your data. Here's what we're doing with it. Here's various disclosures. Here we are, and we're doing these things, and it allows the person to assert their rights under the GDPR and know that you're handling their data. That becomes very problematic. There was a case in Poland that just came down a few months ago where a data aggregator in Sweden had collected 5.7 million records of individuals, and they would monetize this data like you're saying. They had email addresses for about 600,000 of them, so they sent those people emails saying, hey, we have your data with the Article 11 disclosures. And then the others, they had physical addresses, but no way to other way to contact them. So they just posted something on their website pointlessly to say, hey, 5 million people, we have your data. And the regulator said, no, that's not good enough. We expect you to send physical letters to all 5 million of those people, because you had their physical address, giving them the disclosures that are required. And obviously that blew up the whole economics of that data. And the company said, we'll just delete the data instead of doing that. And they got a 220,000 euro fine for their trouble. So that sort of, when you're getting data from third-party sources, that becomes a big challenge in terms of disclosure under the GDPR. Obviously, if you collect the data from the person, you can do whatever disclosures you need to do at that time. And you also get into, when you're aggregating data, say like in ad tech, you have a pool of data that has many sources, and you have many hands in the ad tech ecosystem touching it or doing things with it. You get really complex situations where there might be joint controllers who are agreeing. There's a concept of joint controllers who are agreeing to do the same things together in tandem, and they would need a joint controller agreement. You could have separate, distinct controllers. This ad tech platform's using the data for this purpose, they're a controller, and then this other company in the ecosystem's using it for their other purposes, and trying to trace all of that and flow down all these obligations becomes almost impossible, some would say, to comply with the letter of the law. Does that answer?
Yeah, that helps. I keep wondering, at what point do we become susceptible? You know, I know you gave us sort of the hard numbers of 25 million or 50,000, but you know, all of us are growth companies. Some of us are already there. You know, if there's a complaint, or are there going to be sort of predatory firms that come after us?
Sure. On the GDPR front, a great way to get on the radar of the data protection authorities is to have a horrible privacy policy or privacy notice that indicates you're not up to speed on this stuff. That's public facing. And B, if you have a aggregation of data subject complaints. So they ask you for your data, and you ignore that, and you let those requests pile up, and you don't respond to them as you're supposed to. And then the regulators are looking for hotspots of complaints. Wow, we've got a lot of complaints for this company, and that points them in the right direction. So you could be on the radar that way. Under the CCPA, the original ballot initiative had the whole law there's two parts to the law, I should say. One is all this sort of consumer rights, where they can have rights to access their data and have certain disclosures in your privacy policy and all of that. And then there's another part that says, if you have a data breach of unencrypted data and it's due to not having reasonable security measures around it, then it pertains to a narrower set of data, name plus social security number, that kind of stuff, bank account, identity theft type stuff. If you have that breach, there's a private right of action, which means class action attorneys can come after you. So you're in this tricky situation where it's going to basically kill voluntary breach notification. So if you're not, for whatever reason, you're not subject to the breach notification law and you don't need to disclose a breach, today you might disclose it anyway, but when the CCPA comes into effect, you're not going to want to do that because you're buying a lawsuit if it's this type of data that you've done. The scary thing is that there was an amendment floating through the legislature, and it was recently defeated, that would have made the whole thing subject to a private right of action. So in that instance, if that is revived and passed and enforced that way through class action lawsuits, then you will have class action attorneys sending out bogus data access requests from their quote unquote plaintiffs and seeing how the companies respond and then filing class action lawsuits against them, and would have been a field day. As it stands, all of those data access requests and that part of the law, a broader part of the law, is enforced by the Attorney General, who feels a bit miffed that this was put on his lap. He has to promulgate regulations. He's sort of saying, hey, we're prosecutors, we're not regulators, we don't really like this. And so he was endorsing that amendment to make the whole thing enforceable by class action lawsuits because he feels understaffed. And so what that may mean is, if there is no private right of action, which is the direction it looks like it's going now, the jury's out on how enforced the CCPA will be around these data access requests. You've had earlier laws like Shine the Light law that kind of, they're still out there, they're still in effect, but they kind of went nowhere because there's no teeth in them. So it's really about enforcement. And in the US, we have a penchant for saying, oh, instead of having a regulator staff and an enforcement team, we'll just enable a class action lawsuits. That's a cheap and easy way of enforcing everybody to comply. Or we'll have the FTC hammer someone with a multi-million-dollar fine, and that'll scare everybody else into compliance. Okay,
so what you just said, which I really like, is a couple best practices around preparing for this. The one is not to copy and paste another company's privacy policy.
Correct. Which a lot of people do.
Do you have any resources that you can point us to help guide our teams on privacy policies?
Resources. I know there's some services out there that will help you draft a privacy notice or privacy policy. I don't know enough about them to sort of recommend them, but really the problem is that people perceive it as a boilerplate document, and increasingly it's not. And the main thing you want to do is, there's nothing wrong with looking at a competitor or another company that sort of has your similar profile of data handling practices and grabbing their privacy policy and then adjusting it as necessary, and not as opposed to starting with a blank page. There's nothing wrong with that. What you want to make sure is that there's nothing inaccurate in your privacy policy. Better to not address it than to have something that's just manifestly wrong in there. Particularly if it's in the nature of something, you're doing something worse behind the scenes than what's disclosed in that privacy policy, needless to say.
Okay.
So yeah. And then the other thing is that I get a lot of companies that say, hey, we think we're subject to the GDPR. Can you just dress up our privacy policy and call it good? And there's nothing wrong with prioritizing changing your privacy policy to speak to the GDPR. But if that's all you're going to do and it's hollow behind the scenes, then you haven't really accomplished anything, and the regulator will quickly see that, you've got nothing behind the curtain going on, and they don't like, that's a bad thing. The good thing about the European regulators is they reward honest, good faith effort. But if you just look like you're being cagey or sort of trying to put a false front on that, that's obviously bad.
Silence over vagueness.
Yeah, and the other challenge with the GDPR is if you don't have a program in place, like you haven't figured out how you're going to address the transfer from the EU to the US, you're supposed to cover that in your privacy policy under GDPR. Well, you maybe haven't figured that out. So you got to, in your first iteration of your privacy notice, you may have to kind of mumble past that because you don't have an answer. And then you start working on your low-hanging fruit, your privacy program in the background, and then you start to kind of revise that notice to flesh it out. At the end of the day, we all know that we don't have enough resources to do everything we want to do. And so the exercise is looking at the GDPR and saying, okay, I think I'm subject to this. What's the low-hanging fruit? What's the highest risk areas? And how can I deploy my resources knowing that it's never going to be perfect? And
to get help on that, would we go to firms like yourself, or are there services, standard services that?
Yeah, I can speak to that a little bit. So there are both. There are law firms and lawyers like myself that will help build a compliance program. There are any number of consultants who are non-lawyers who will help build out privacy programs and be perhaps a little bit more, maybe a little more cost effective, but will sort of walk you down the path. They'll maybe help you do a data inventory and mapping exercise and sit there with you and hold your hand a little bit more than might be cost effective for an attorney to do. So if you're really just like, I need somebody to just kind of walk me through and crack the whip behind me, that might be a better option. But the one thing to watch out for is that there are a lot of essentially security services or managed security services out there that when GDPR came along, they sort of stuck GDPR on their website and said, we'll help you comply with the GDPR. And really they're about security, which is just a small subset, or an important but small subset of the GDPR. The last thing is there are tools like OneTrust, which are basically robust data collection and surveying tools. So you can push out a questionnaire as part of your data mapping exercise, or you could create a self-service portal for somebody to report a breach within your organization, or those types of things. So there are tools like Nimity and OneTrust that will help you handle, sort of get your arms around some of the project management around that, but they're not substitutes for, a lawyer or a consultant. Really quickly on that, an interesting anecdote, I was talking to an attorney who does works in this area as well and works on tech agreements, and he was saying he sees a trend in negotiating parties where in the past they would say in the contract, give me access to all this data, and now he's increasingly seeing them say, you rep and warrant that you will not give me the data, because there is exposure around it. So one of the principles of the GDPR is data minimization, the core principles. So it says, if you don't need it, don't collect it. And by having it laying around, if you don't really need it, you're just adding to your risk profile. If you've got 1 billion records and you don't need access to them, maybe encrypt them and take them offline and set them off your network and reduce your risk footprint. But to get to your broader question, there are a couple things there. If I'm a processor and I'm working for a controller, my guardrails are I'm supposed to only use the data for purposes of providing that service to my controller. And so if I start to do other things with the data, like feed an algorithm, it starts to get a little bit squirrely. You have to argue that I need to feed this algorithm to provide you the service, and that may be okay. But if you're just sort of using it for some total other purpose, then you kind of pull yourself into a controller. Obviously, if you're out collecting data directly from an individual that you don't need to provide the service, you're not using the application data that was normally being fed to you, but you're sort of going and collecting additional data. That's you're putting yourself in a much riskier standpoint, because you have to justify why you're collecting that data. You can't sort of shuck and jive and say, well, I'm just doing slightly different things with the data I was originally being provided. Now you're out collecting fresh data. And so that's a challenge there under the GDPR, which again has this sort of purpose limitation built into it. The CCPA doesn't talk about purpose. It doesn't talk about why you're using the data for. It's more about who you're selling it to or sharing it with, and are you respecting these various consumer rights in controlling and handling the data.
So if you're keeping it in-house to improve your services, it's less of a yellow flag, right?
Right, and you probably in your contract with your customer, whereas you might have said, we reserve the right to use this data. You might not want to highlight that. That's going to kind of maybe put a flag up for them, possibly. Sometimes you say, we're going to aggregate and anonymize the data, and then we're going to use it to improve our data.
Jonathan posted that the GDPR says that companies must provide, quote unquote, reasonable level of protection for personal data, but doesn't define what that reasonable is. Do you have any way for us to make that more discreet?
Yeah, I unfortunately, to some degree, yes, but it's tough. So the article that speaks to that security of processing in the GDPR is very short. It encourages encryption and pseudonymization. There's some recitals that are associated with that elaborate a little bit, but I think they understood that if they're prescriptive about security, then it's going to be out of date instantly or very soon. So they just sort of say, you figure it out. And I think what people do is they sort of look around the industry, its standards. Obviously, if you're SOC 2 certified or you're ISO certification, you can rely on that. That would be I would think adequate. But you kind of just have to be in step with good industry practices.
But at that point, you probably have representation of some sorts to help quantify or define what that is.
Right, and it's very much associated with the risk to the individual. So if you're just dealing with names and that's it, then that requires a different sort of, they understand that requires a different level of security than if it's,
right,
much more sensitive data.
So where is this going, and any final thoughts for us?
Sure. So the story of all this is that we've created an environment in the internet and IT systems that wasn't really built around, it was built around security to some degree, but not, extensively. And it certainly wasn't built around privacy and having the ability to track down a particular person's information broadly defined and control it in unstructured pools of data on somebody's thumb drive, in emails, like these laws require. And so that's the environment we've created. We've dumped a lot of our life and our economy onto the internet. And now we're seeing this inflection point where these laws, the GDPR and CCPA, are being dumped on top of that. And they require something that's fundamentally at odds with what we actually do. And so we're seeing the start of a really painful process of trying to sort of, I was listening to a large company that was talking about these access requests, and they were saying, we just literally can't do it. You can't delete everything from every email. It's impossible. So it's a painful process. You need to think about these things early in your product development cycle. That's a principle of the GDPR, which is called privacy by design. So you build and consider privacy in the development of the product. But on the legislative standpoint side, we have GDPR, CCPA, we have privacy laws in Korea, Argentina, Brazil, Australia, China, that are all popping up all over the world. And then we have about a dozen, or actually over a dozen states right now that are have in the works privacy laws that either mimic the CCPA or sort of like the CCPA, or maybe even the GDPR. In the case of Washington, that one recently failed, but they could go at it again. And so what the problem is that we could wind up with a patchwork of laws that are all similar but slightly different, or maybe significantly different, and it's going to be very difficult to comply with these in a borderless age of information. And so the Commerce Department was tasked with creating a blueprint for a federal privacy law. They're holding hearings on it. I don't think it's going to be passed in the next year or two, but I think the tone of the discussion has gone from should we pass a national privacy law to we have to, but what's it going to say? And then the $20,000 question around that will be, will it preempt the federal laws entirely, or will it preempt them partially and resolve that patchwork compliance problem that we have? The privacy advocates would say that if you preempt these state laws entirely, you're never going to get that catalytic event like California passing the CCPA to trigger a new age in privacy protection, because it's just this uniform federal law, and there's no mechanism for there to be a paradigm shift. So
is there a way for us as CTOs to stay informed? Is there some source of truth that you trust that we can keep an eye on, or are we scouring the internets for info?
Yeah, if you're looking for resources online, the better quality resources are the major law firms like Field Fisher. There's an excellent data protection lawyer in Silicon Valley, a British guy named Mark Webber, and they put out a lot of publications on these issues, and you can rely on them to be accurate. White and Case, Bird and Bird. These are big firms that really know their stuff and put out very detailed publications. The challenge is they might not be eminently readable for a non-attorney. And so the risk is when you get something that's sort of drafted by a tech firm to tech people, it might have you need to confirm anything that's, in there.